Affluenza case. Four pedestrians killed and 2 injured. A soft, lenient punishment, deciding before American court to a wealthy white teen. A tale of 2 teenagers in Texas. What happened? In 2013, 16-year-old Ethan killed 4 pedestrians and injured 2 others while driving drunk. His defense team argued he suffered from affluenza, a supposed psychological affliction where his wealthy upbringing left him unable to understand the consequences of his actions. Affluenza, a faux-disorder implying his wealth impeded a sense of personal responsibility. This case revolves around 2 starkly different sentences within 1 year, handed down by the same Texas judge, Judge Jean, to 2 teenage boys, raising intense public outrage over racial and socioeconomic bias in the justice system. Case 1. Ethan, the wealthy white teen. The crime. In 2013, 16-year-old Ethan, while driving drunk with a blood alcohol level 3 times the legal limit, crashed his vehicle. The crash killed 4 pedestrians and injured 2 others. The defense. Ethan's legal team infamously argued he suffered from affluenza, a discredited psychological claim that his privileged, wealthy upbringing left him unable to understand the consequences of his actions. The sentence. Despite high number of fatalities, Judge Jean sentenced Ethan to 10 years of probation and ordered him to enroll in a luxurious private rehabilitation facility. The decision was widely perceived as an exceptionally lenient, non-custodial sentence for a reckless act with catastrophic results. Case 2. Max, the poor black teen. 1 year earlier. The crime. In 2012, a 14-year-old black boy referred to here as Max. For clarity, he and his friends had stolen a car prior to the incident. He jammed out of the car and killed another teen with a single powerful punch during a confrontation, causing the victim to strike his head on the pavement. The victim died 2 days later. The sentence. Judge Jean Boyd sentenced Max to 10 years in a juvenile detention facility, described as basically prison for juveniles. With no rehabilitation options available to him, he faced the full weight of the penal system and could potentially be transferred to an adult prison at the age of 19. A tour of the public outrage. The fury was not directed at a single ruling in isolation, but at the glaring disparity between the 2 outcomes under the same judge's jurisdiction: wealth versus poverty. Ethan's family wealth provided a path to a treatment-centered sentence in a private facility. Max, who was indigent, had no such option and was given a harsh custodial sentence. Incarceration of the poor black teen was seen as powerful evidence that the justice system is not blind, but is influenced by race and class. Counterpoint, the legal rationale. Some argued that Judge Jean's decisions were legally grounded in the distinctions between the 2 cases. Crime type. Ethan's crime was tried as a nonviolent offense, reckless homicide via drunk driving, while Max's was a violent, intentional act homicide via a punch. Juvenile sentencing laws. Sentencing a juvenile like Ethan to a secure facility for a non-violent crime might have resulted in a very short stay. The 10-year probation with strict conditions was framed as a way to maintain longer-term control, a theory tested when Ethan violated his probation after 2 years. Conclusion. Regardless of the legal technicalities, the affluenza case remains a potent symbol in the public consciousness of a 2-tiered justice system, where wealth and race can dramatically alter one's fate in a court of law.